judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Reason to create a separate negligence charge, that you couldn't separate out the sweeping operation. There was no independent negligence in this case, because the only testimony was that all the water nozzles were working, and that the low water indicator light never came on. It had been refilled at least once during that job. And so I don't think there was any reason to create a separate negligence charge on either that or on the issue of signage, because there was no signage required for mechanical street sweeping. And with that, I thank the court.
Thank you. Wilson against State of New York.
Ready, of course.
Thanks, Fred.
Mr. Golden.
If it please the court, my name is Lawrence Golden, and I represent Mr. Wilson in that case involving a snowplow accident in March of 1994. And I would like to jump my argument immediately to a concern that Judge Wesley had and voiced in his questioning in the previous case. And that concern is there appears to be, and every court has said this, a conflict in that last sentence of Section 1103, the sentence that talks about the duty to use due care, and then goes on to talk about not relieving an operator from the consequences of his reckless disregard. And I'm going to jump to it because it was my intention today to advance to this court a new theory that I don't believe has ever been advanced to any court that has dealt with either this section 1103 or 1104. First of all, and incidentally, this new theory, this new approach, if you will, interpretation, gets rid of any conflict and makes the statute harmonious, and it's my contention that this interpretation is what the legislators intended. First of all, it's apparent from examining the records of the other cases, and in the case of Saarinen v. Kerr in particular, that the courts have always, and the litigants have always, in dealing with this section, had an underlying assumption that the entire sentence was focusing only on the issue of civil liability. They were always assuming that both the first half and the second half of the sentence was focusing on, quote, civil liability. They assumed that the legislators, in putting this sentence together, were attempting to define in both the first and second part of the sentence civil liability rules. Well, I would contend most respectfully that that may not have been a valid assumption. And in fact, I submit that there is an alternative interpretation in which does not use that assumption and which brings the statute in harmony. And let's look at the two parts of the sentence. The first part of the sentence clearly defines a duty. That's a duty to proceed at all times with due regard for the safety of others. And as this court has recognized and stated in the Saarinen case, that is defining, in essence, the duty of ordinary negligence, the ordinary negligence standard of care. It used the term duty, and we know duty is something that is normally set forth in a statute in order to establish a standard of care. But then the legislators go on to the second half of the sentence, and they don't use the term duty. They say, it states, the provision says that it shall not protect operators from the consequences of their reckless disregard for the safety of others.
Well, let me ask you this question. That's exactly the same language we construed in Saarinen, isn't it? 1104E. It says the very same thing. Shall not relieve the driver of an emergency or authorized emergency vehicle from the duty to drive with due regard for the safety of all persons, nor shall such provisions protect the driver from the consequences of his reckless disregard. So are you asking us to interpret the identical language differently in 1104 from 1103?
Well, Your Honor, Judge Levine, I may very well be asking you to reconsider the rationale, not necessarily the holding in Saarinen v. Kerr, but the rationale, if I may be permitted to continue. If, in fact, when they use the word consequences, if, in fact, they weren't talking about the civil liability consequences, what then were they talking about? What consequences other than civil liability? And the answer becomes very clear. They were dealing with the administrative consequences and the criminal consequences. And the interesting thing is that if you look at Section 510 of the Vehicle and Traffic Law, which is not a section they were exempted from, if you look at that section deals with the suspension and revocation of driver's licenses. And subsection 3E of that section says that you can have your license suspended or revoked for operating a motor vehicle in a manner showing a, quote, reckless disregard for life and property of others. Now, that statute was enacted in 1959 at the same time that 1103 was enacted and 1104 was enacted. And it's curious that the only place in the entire vehicle and traffic law, the only place that the term reckless disregard appears is in Section 510 of the Vehicle and Traffic Law and 1103 and 1104. And so I think the legislatures were intending to relate 1103 and 1104, at least 1104, because I have to, in a moment, I'm going to cover the fact that the legislators in 59 did not have that sentence in 1103, and that's a distinguishing factor. But the fact is, by using that same terminology, what they were saying when they talked about the consequences was not the civil liability consequences, but rather the consequences of maybe losing your license by virtue of Section 510 of the Vehicle and Traffic Law, or worse, if they should kill someone, God forbid, in the course of the reckless disregard, being faced with a criminal charge of criminally negligent homicide. So this brings the two sections of the statute in harmony, the two sections of the sentence. The first one defines the civil liability duty, and the second one tells these people, even though you don't have to abide by all the rules of the road, including, incidentally, reckless driving, even though you don't have to abide by those, we're going to make you responsible for the administrative and criminal consequences. Namely, you might lose your license, you might go to jail. And that's what I think the legislature intended then. Now, there's another point that I think you smiled at, and Judge Levine, and that is that in 1959, when this whole statute was enacted, it was enacted through a process where there was a legislative committee that studied all of these statutes side by side. And they looked at 1103 and what was then 113, I believe, and 1104, which was then 114, and they were written up right side by side. In one, they put this language, and in the other, they did not put this sentence. This sentence was curiously missing from 1103, but was included in 1104. And I would suggest to you that under the rules of construction, which say that if a legislator puts words in a statute, you must assume that he intends those words. By the same token, the rules of construction hold that if the legislature excludes words from a statute, he intends that exclusion. And it's my contention that in 1959, when the legislators put it in 1104 but didn't put it in 1103, the statute we're dealing in, they intended that. And I don't think that we can assume otherwise, because the statutory construction rules tell us that we have to assume an exclusion is intended. Now, 19 years later, Senator Padovan had an idea that he was going to put this sentence back in because he thought it was left out by inadvertence. There was no legislative committee at that time that studied it. It was done almost on a whim. That he looked at the section, he saw it missing, and said, I'm going to put this back in because of inadvertence. And so at that point in time, in 1974, they put in that critical sentence into 1103. Now the question is, whose legislative intent are we going to look at? Are we going to look at the legislative intent of the legislature that enacted the whole statute in the context of the whole vehicle and traffic law? Or are we going to look at Senator Padovin's legislature that thought, without any basis stated, that it was inadvertently left out?
Let me
I
ask you
suggest-
this, if your interpretation is right, does it mean that ambulances and police cars and fire trucks are subject to a straight negligence standard and not to a reckless disregard standard? That's what it would mean, right?
My interpretation, which brings that first section into harmony,
It
would
would have
mean
to,
that.
it would have to mean, then, that the ambulances and fire trucks are not held to a reckless disregard standard, but they're held to ordinary negligence.
That's correct, but
Okay, that's your interpretation, all right.
that would be my interpretation.
Well, that's
I'm a person-
one way to make it work. I mean, I agree with you, that, but you have to yield that point because the statutes are parallel. So the question is whether that is a appropriate interpretation.
I think it is, and Your Honor, as stated in Saarinen v. Kerr, when you're dealing in an ordinary negligence situation and you're dealing with something like a police car or fire truck that's operating under stress, very fast conditions or split-second decisions, the standard, even under ordinary negligence that applied, is very different than the standard
Well, it's
that would be applied
an
to.
interesting suggestion you make, but we know that the very beginning of this statute, which doesn't contain the problematic language, also exempts these vehicles, both my snowplow and Judge Rosenblatt's ambulance, from the provisions of the rules of the road, like speed in the zone, speed not reasonable and prudent, failure to exercise due care, failure to keep right, failure to stop at a stop sign. So all of a sudden, you've got all of the, which are generally the primary indices of negligent conduct, thrown out the window. And so now what is negligence for an ambulance driver under your theory, or a snowplow driver under your theory, other than something approaching reckless conduct?
Well, again, I think it's...
How do we I guess what I'm saying to you is, given the way you postulated this, it's interesting, it's different, but I have to think about it, and when I think about it, I say, okay, now, all right, so you want to impose negligence, but we can't charge violation of the vehicle and traffic law because those vehicles are exempt from it. So the jury's not going to be allowed, unlike your earlier, Mr. Riley's, or Ms. Riley's attorney, can't charge violation of statute, some evidence of negligence. So how do we understand what due care means? It's a different due care for an ambulance driver, snowplow driver than you and I when we're schlepping along on the throughway.
Well, I understand that, Judge.
Right?
That's correct, Judge Wesley. However, as is noted in the Saarinen v. Kerr case, that how you apply the ordinary negligence standard varies depending on the type of situation you're dealing with. If you're dealing with an emergency situation, obviously the application of the rules of ordinary negligence, because the reasonable and prudent man in the same circumstance is different, would be different. But
that's the rub. Police officers are taught how to drive defensively and taught how to drive under stress. Ambulance drivers receive training with regard to operating an ambulance during a period of time in which the lights and sirens are engaged. And they're aware of the fact that they don't have to observe the speed limit. And so now all of a sudden you're approaching reckless conduct and understanding what is reckless, because reckless is should perceive the danger and disregard it, right?
that's correct.
So recklessness for an ambulance driver is professional negligence, is that it?
I suppose you might be able to call it that, although I think
doesn't that then-
recklessness goes obviously beyond that,
Well, then,
with respect to any kind.
That's another way to harmonize those inconsistent sections, isn't it? To recognize that maybe the standards employed for these kinds of operators measure their perception of the danger and ultimately help to define their recklessness.
Judge Wesley, I agree with you, except that I think in order to do that, you have to go beyond the four corners of the sentence, of that particular section, and look at the situation, whereas applying my approach, or the approach that I've tried to advance today, basically the sentence becomes harmonious.
How does a juror understand, in your case, your snowplow case, how does a juror understand the safe operation of a snowplow other than to understand what the snowplow operator is taught?
Well, I think that's obviously defined by experts who testify or by the lawyers who frame
And
the...
not by the rules of the road.
No, but see, the interesting thing, and Judge Rosenblatt brought this out, is that they've given an ordinary snowplow or rural mail carrier greater freedom from the laws than they've given a police vehicle, an emergency vehicle. On the emergency vehicles, at least each in the set, they don't release them from it, or they don't exempt them from all of the rules of the road. It's just very limited rules of the road, and interestingly, in relieving them from those limited rules of the road, they also place some restrictions on them that will ensure that they are acting with due care. On the other hand, with hazard vehicles and work vehicles, what they are doing is essentially saying, you don't have to abide by any of the rules of the road, and the counterbalance was that the legislature in '59 obviously intended was, we're going to do this, but we're not going to change or fool with the standard of civil liability, as long as we're going to give you the freedom from these roads. Because work vehicles, in order to perform their work, work vehicles have to occasionally, necessarily, violate the rules. They may have to back up on a highway that they're not supposed to back up on. They may have to go the wrong way on a road in order to do it. The legislature wanted to facilitate their being able to do the work, but certainly the legislature never intended to relieve them of the liability, civil liability, and the duty to exercise due care, the rule of ordinary negligence.
Thank you, Mr. Gould. Thank you. Mr. Goldfarb?
Good afternoon. May it please the court. The appellate division correctly held that the snowplow engaged in plowing snow from a highway in this case was subject to a reckless disregard standard for civil liability purposes. The second sentence of section 1103B sets forth the standard of reckless disregard for the safety of others in claims arising from the conduct of any operator of a motor vehicle or other equipment while actually engaged in work on a highway, using the same statutory language construed by this court in the Saarinen case as setting forth a reckless disregard standard for emergency vehicles under section 1104E. We submit that under any reasonable definition, a snowplow engaged in plowing a highway is a vehicle actually engaged in work under a highway under the plain language of the statute. Although the statutory language is plain enough, any conceivable question on this is answered by the legislative history. The original report by the Joint Legislative Committee on Motor Vehicle Problems explicitly states that snowplows were intended to be covered by the original 1957 statute, which set forth the Title VII exemption. When the statute was amended in 1974 to set forth the reckless disregard standard, the legislative history makes clear that all highway maintenance vehicles were intended to be covered, and the memorandum from the Deputy Commissioner and Counsel for DMV, which I quote in my brief, explicitly cites a snowplow as the type of vehicle that would thereafter be subject to the reckless disregard standard. With respect to the standard of care imposed, by using the exact same statutory language as in section 1104E, it's absolutely clear that the legislature intended to impose the same standard for civil liability purposes that it had previously enacted for emergency vehicles, and again, the legislative history confirms this. In particular, I'd refer the court to the memorandum by Senator Padovan, the sponsor of the bill, which clearly states that the intent of the amendment was to, quote, apply to all persons, teams, or operators engaged in work on a highway the same standard of care now required by section 1104, subdivision E of the Vehicle and Traffic Law, to be observed by operators of authorized emergency vehicles, unquote. Now, I think realizing that the plain language of the statute, as well as its legislative history, really refutes his position, the claimant in his brief has asked this court to simply judicially amend the statute and limit the application of the reckless disregard standard to vehicles operating in a work zone as defined by Vehicle and Traffic Law section 160. This argument should be rejected for the simple reason that this limitation is nowhere to be found in the statute, but rather the legislature enacted the standard broadly for all vehicles actually engaged in work on any area of the highway. I think it's highly significant that the term work area has been explicitly defined in the vehicle and traffic law, and the legislature has used this defined term as a limitation in many other sections, but not in 1103B. Thus, when the legislature has intended that a statute only apply when a vehicle is being operated in a demarcated work area, it has made that intention clear in the statute. I'd also point out that Vehicle and Traffic Law, Section 160, defining a work area was not enacted until 1984, while the reckless disregard standard was added to 1103B in 1974. So not only does claimant ask this court to judicially legislate, he would have it do so by resorting to a statutory definition which wasn't even in existence when the legislature imposed the reckless disregard standard. In addition, a work area limitation really makes no sense as applied to a snowplow, which the legislative history makes clear were intended to be covered, and which obviously must engage in their plowing operations on all areas of the highway, and not just in limited areas. Put another way, a snowplow is always in its work area when it is engaged in its plowing operations. I'd also point out that there's absolutely nothing in the legislative history that supports this newly invented work area limitation.
Question here on, there's a very compelling memo from counsel to the Department of Motor Vehicles in which the counsel says, it's at page 17 of your brief, it says that under the present law, snowplows have exemptions that allow them to speed and do other things which may endanger the public. They're not subject to any rules of the road, and he likes the idea that they're subject to rules of the road. At what point was that a memo written? Was it written as a suggestion to change the law, or was it written after the bill to include the reckless disregard standard was circulated? Because apparently the legislature didn't follow exactly what the Department of Motor Vehicles was suggesting. They added yet another element. They said, yes, true, there should be due regard for the safety of others, as suggested in here in the Department of Motor Vehicles, but then they added this additional dimension of reckless disregard, which does not appear in the suggestion of the Department of Motor Vehicles. So I can't tell, and I need to know the sequence, the chronology to put this memo into context.
I'm not entirely sure when that memorandum was prepared. I think it's likely that that memorandum was prepared as a comment on the proposed legislation.
The legislation that included the reckless disregard.
I don't know that for a fact, but that would be my best guess. But I think what's clear is that the legislature went ahead and enacted the same statutory language which they used in Section 1104E. And the point was brought up about the language using due care, also using reckless disregard. This was something that was squarely confronted in the Saarinen case, and the court commented on it. And what Judge Titone wrote in that case was that if the standard was just going to be due care, there would be no reason to put in reckless disregard. And the best interpretation of that, admittedly rather odd language, is that the statute imposes an affirmative duty of due care on the operators of all these vehicles. But when it talks about the consequences...
The care that's due is not non-reckless, or something not above recklessness. Is that it? I'm sorry. Go ahead.
No, I would say that the statute is affirmatively telling these operators they should not be negligent. But when it talks about the consequences, it's clearly at that point talking about when civil liability will obtain. And at that point, when it talks about consequences, it talks about reckless disregard for the safety of others.
That's certainly how we read it.
You have an obligation not to be negligent, but the state and municipalities are only going to be civilly liable for reckless disregard for the safety of others.
In any event, to go the other way would essentially require overruling Saarinen.
It would require overruling Saarinen, and as Judge Rosenblatt pointed out, imposing a negligence standard for emergency vehicles also. I think it's also important to understand that under claimant's theory, a snowplow plowing a highway in an area other than a work area would not qualify as a vehicle actually engaged in work on a highway, and thus under the first sentence of Section 1103B, would only be exempt from the stopping, standing, and parking provisions of Vehicle and Traffic Law 1202A. Now, as I demonstrate in my brief, snowplows need to be exempt from many other provisions of the Vehicle and Traffic Law to engage in their plowing operations, and it must be presumed that the legislature intended that snowplows be exempt from all provisions of the Vehicle and Traffic Law necessary for them to engage in their ordinary function.
Procedurally, this was dismissed at the close of proof by Judge McNamara?
That's correct. The judge
Right, he made
reserved
some
decision on the
credibility
motion and then issued a decision.
He made some credibility determinations and found that the operator did, although it was, he said that he was, there was no proof that he acted with conscious indifference to the outcome. To use his
That's
words.
correct. As fact finder, the court found that the proof did not rise to the level of reckless disregard.
All right, so this is at close of proof after the judges decided and heard all the proof. Was there any proof in the record about regulations concerning the operation of the snowplows during hazardous
No,
periods?
there was not, Your Honor.
This was during a pretty substantial snowstorm, as I understand it. The plaintiff estimated the site distance at 50 feet, and the driver's estimated
And the
at 100
driver
feet.
estimated 30 to 40 feet, also testified there was a glare created with his headlights, and he really couldn't see much in front of the plow in front of him. The claimant testified the conditions were so bad that he considered turning back once or twice in the middle of his trip.
Of course, this is part of the problem of the conditions under which some of these vehicles operate. They operate in times of severe weather conditions.
That's correct, and I think that the legislature could well have determined that certain work vehicles are in fact somewhat akin to emergency vehicles, and a snowplow is an excellent example. Snowplows have to go out on the highways during snow emergencies under treacherous conditions where reasonable persons probably wouldn't go out on the highway at all, and I think there was a substantial justification for them to conclude that operators of these vehicles shouldn't be held liable for a mere failure of judgment or simple negligence when operating under these circumstances. I think that in the end, claimant simply believes that there's less reason to apply this standard of care to work vehicles as there is for emergency vehicles, and on this, claimant's addressing his arguments to the wrong branch of government. That was a determination for the legislature to make. The legislature has spoken in Section 1103B, and the wisdom of this legislation is of course not a matter for this Court of Appeals. To the extent that claimant believes that these vehicles should not be governed by this lesser standard, we think that his proper avenue of recourse is with the legislature which imposed it in the first place and not this court. I'd like to briefly address the question of whether the state had to plead this statute as an affirmative defense under CPLR 3018B. The standard of care in 1103B is not a defense at all. It imposes no burden on the defendant, and its only legal effect is to define the extent of the duty owed to the claimant and the consequent burden of proof which the claimant must meet at trial to impose liability on the covered persons. Where a claimant can't establish reckless disregard, he or she can't state a prima facie case and impose liability regardless of any defense the defendant might assert. And this court's decision in Ferris v. City of New Rochelle, which I discuss in my brief, is precisely on point, where this court held that General Obligations Law 9103 need not be pleaded as an affirmative defense because just like Section 1103B, its sole effect is to establish the substantive law defining the extent of the duty owed to the claimant. And I think the rationale underlying this is that 3018B by its terms only requires a matter to be pleaded as an affirmative defense if it is likely to take the adverse party by surprise or raise issues of fact not appearing on the face of a prior pleading. And simply put, the surprise sought to be prevented by 3018B is not mere ignorance of the law of a statute which sets forth the claimant's burden of proof at trial. In this case, the claim itself makes clear that claimant knew that he was injured in a collision with a state-owned snowplow that fell within the parameters of Section 1103B. Claimant should have located the statute setting forth his burden of proof, and the state's assertion of the statute can't be said to have surprised claimant within the meaning of 3018B. If there's no further questions,
you,
we
Mr.
would respectfully
Goldfarb.
request the order appealed from be affirmed.
Thank you. Bliss against State of New York.
Ready.